Talking Law on Radio 97, our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us every Thursday morning. She brings all her legal expertise with her. She provides some general advice on the latest of hot topics, and we do have a couple of very hot topics today. She's got experience that spans more than 25 years in the area of property and commercial law. She prepares wills as part of estate planning and litigation, and she's with us once again. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. Good morning, Wayno. So we're kicking off this morning with a local story, and it's going to lead us into this segment. And Despina will explain basically what not to do when buying a property, whether it's at auction or through other sort of means. This segment follows a crazy, unbelievable story that came up in the Gold Coast Bulletin in regards to a home that was purchased by this lovely couple at auction, but it turned out that they never actually legally owned the property. So, Despina, can you talk us through, in, I guess, the most simplistic way you can, what actually happened and what not to do when buying a home?
Yes, so I will, and I want to talk about this, and it is a complex case. So I have read the entire case. There's pages of it. It involves complex areas of law in Queensland. What we're not going to do this morning is talk about those complex areas of law, because that's not really going to help the listeners out there. What we want to do is talk about the story. How could this have come about? How could someone buy money for a property and never legally own it and stay in possession for 4 years? And from reading the case, what I can also say 100% is to give some helpful tips about what buyers should do and to avoid this scenario, because what definitely came out in the case is that the court said, look, had the buyers done this, and they could have done this quite easily, it might have had a different outcome. So whilst we don't want to, I suppose, rub salt in the wounds for the Moorcrofts who have lost their home, which they never legally owned anyway, what I want to try and do, and I will do, is give this advice to buyers out there to do a little bit more due diligence, which is really what it came down to, unfortunately. So let's talk about what happened. Okay, so the headlines that have gone around in the last week say Gold Coast couple never legally owned the home. They purchased at auction. The court has ruled. So yes, there has been a trial. It was decided on the 24th of February in the Supreme Court. And essentially, this is what happened. And I'll try and be as simple as I can to explain the set of facts and circumstances, because those facts and circumstances leading up to the settlement were very complex as well. So in a nutshell, these people, the Moorcrofts, right, went to an auction. And at the auction, they signed a contract of sale to buy this property at Mermaid Beach. Okay, I think the purchase price was 1.2 or thereabouts. All right, so auction contracts are always unconditional. Okay, so that there are no conditions typically. That's why you go to auction, you know that, you're cashed up and you're ready to buy. So they signed a contract, and settlement happened, or was earmarked to happen, a few weeks or months later. But what happened is, when there's a lot of things happen from the contract date to settlement. When they got to the settlement, okay, they did the right thing in that a buyer has to hand over money to the seller, right? So they've got contractual obligations, hand over the balance monies owed to the seller. And the seller then hands over a document called a transfer. Okay, and the transfer is a document signed by the seller, which is also signed by the buyer, right? And then the buyer can take that after settlement and go and lodge that at Queensland Titles to get their name on the title. Okay, and that's how it always worked for paper settlements. So this was a paper settlement in 2018. We are now in 2023, where we have the e-conveyancing mandate in Queensland, where there are no longer paper settlements, and it's done electronically, instantly on PEXA. Okay, so and that's another issue. In today's times, the outcome would have been different, I suspect. But look, let's go back a bit. So what happened is, an 83-year-old woman, Miss Issa, right? So the case is called Issa versus Owens. So, and there are other parties involved, but Miss Issa was 83. She owned this property for several years, and she was a migrant that came to Australia many, many, many decades ago with her and her husband, and they worked very hard, tirelessly, as the court said, to buy this property at Mermaid Beach. Okay, and then She divorced, but as part of the divorce, she ultimately owned this property. Okay. What happened is that, unfortunately, too, for this lady that owned the property, Miss Issa, who still owns it today, she started to suffer with dementia. So her daughter helped with this court case and ultimately took it on. But what happened is the son, she had a son and a daughter, and the son forged her signature on a mortgage that became registered on the property, right? Well, she owned it and she still owns it, but yeah, well before any sale of the property. So she owned a home. Her son went and forged her signature on a mortgage. That mortgage got registered. Then that mortgage went into default. And then that mortgagee, which was not a major bank, it was a private lender, went and exercised their power of sale, like all mortgagees have, all lenders have in their document, to say, okay, well, if you're in default and you're not going to pay up, guess what? I'm going to go and take possession and go and sell the property. And that's what they did, okay? And all based on the signature that was forged on this mortgage, the signature which was also witnessed by someone else. That was also a fraud, because that witness, turns out, never actually witnessed the person's signature in person. So that was another element of the fraud that happened. And then ultimately we fast forward to the auction day. Okay. So the Moorcrofts are none the wiser. They're an innocent buyer. Yes, absolutely. And I feel for them. Sure. No one wouldn't feel for them, but they've trundled along to the auction. They've gone and said, okay, great, want to buy this property. They can see it's a mortgagee in possession sale, because the contract had to say that. Okay. So they go, all right, no problems. That happens, lots of times in the past. Mortgagees are selling this property. Someone's gone into default. Okay. So then what's happened is, from the time they signed the contract to settlement, right, there was a lot that's happened in the background. And when they went to the auction, the contract itself had a very old title search. Okay, very old. It wasn't an up-to-date title search, and that shouldn't have happened, because when the mother, Miss Issa, found out about the fraud, okay, and she did ultimately, and confronted her son, she then found out that these lenders were trying to sell the property from under her. So what could she do as an owner? It was terrible. She had no idea this was happening. What could she do? She lodged a caveat. So, yes, the court talks about, yes, she lodged a caveat. What else could she do? She lodged a caveat to try and stop this auction sale, or the sale from going through, because it was sold at auction, but she wanted to stop the settlement. She wanted to stop any transfer of ownership happening. So the caveat was lodged. Now, there was a lot that happened in the lead up to settlement, but ultimately what happened is she was pressured very much to release that caveat from the private lenders who were threatening her with lawsuits. She didn't have the money to go and defend such a lawsuit, even though she obtained legal advice. But ultimately, she agreed to release the caveat. And if the caveat was never released, the settlement where the Moorcrofts went along and paid money for the property, would never have happened. So she felt pressured. She got the caveat taken off. Yes, she got $40,000 was reported as a result of that, but she reserved her rights when she released the caveat. Then the Moorcrofts went, great, we can settle. Great, I'm going to settlement, handing over the money. I got my transfer. They gave it to their lawyer, who then later on lodged it at, land titles in Queensland to get the change of ownership happening. And remember, this is paper settlement. So in today's times, none of that would have happened. It would have been automatic on the same day through PEXA, through the electronic settlement process, where title transfer would have happened instantly. Okay. So then what happened from the time that they settled? They paid the money, they moved in, they took occupation, got the keys, all of that. So for all intents and purposes, they own the home. Then what happened is the Registrar of Titles in Queensland found out about the fraud, or the potential fraud back then, because there wasn't a court ruling, and said, you know what, this doesn't look good. I've been made aware that there's fraud. I'm going to lodge my own caveat. So the Registrar of Titles, which is a big deal, decided there's enough evidence here to go, you know what, we're going to make some inquiries, because the owner reported this before settlement, way before settlement, and told me that there's fraud happening. I'm going to make my own inquiries. And she lodged the caveat herself. And that just stopped the transfer of ownership happening, to put it very simply. So that's why the Moorcrofts never actually owned it legally, because the registrar's caveat stopped that transfer from registering and stopped the transfer of ownership. And then everybody went off to court. And 4 years later, we've got a ruling.
Oh my gosh. But they still got the keys. So though this wasn't like, that blows my mind. How did they get the keys? So obviously these people involved, agents or whoever it is, there's a lot of dodgy people involved in that whole process.
It's very unfortunate, and I was feeling for everybody reading this case. It was terrible, and it should never ever have happened. And fraud has happened, in all the states and territories in Australia, unfortunately. And now we have changing of the laws with verifying people's identity, making sure that there are strict legal requirements to face-to-face witnessing of signatures on mortgages. I myself recently had to witness a mortgage for a client who was getting private funding. And one of the requirements from the lender in Sydney was you need to take a photo of your client signing the mortgage document. You need to take a photo of the mortgage document that we gave you. And then you need to certify on the back yourself that I witnessed this signature on this date at this time. And I had to certify that and give it to the lender. So that was,
That's good.
And that was, so that's the requirements. But none of that was complied with, which is why ultimately the court found that the mortgage and the transfer, they're all void, because the mortgage that allowed the auction to go forward was all forged.
So Despina, just briefly, how could this have been different? What could they have done to have had a different outcome here?
Okay, so if you're going to an auction, so I want to go back a bit, and this is not rubbing salt in the wounds, but I do need to give this advice to buyers out there. One, if you're going to an auction, and you know that it's coming up, say this Saturday, you have every right to email, ring the agent, say, great, I wanted to view your auction contract before the auction takes place. So
that's awesome.
That happens all the time.
Yeah.
So before you even turn up at the auction, when you're all sort of adrenaline's running and you want to get that, you want to be the winning bidder.
Excited. Yeah.
Forget about all that. Forget about it. Yes, that's all exciting, but let's be realistic. Let's look at the contract. I want to see that contract before the Saturday auction, right?
Yep.
So get that contract, give your lawyer a look at it. Now, if the lawyer's smart, like some of us are, right? They would have seen.
Not everyone, though. Not everyone.
Not everyone. No, that's not everyone. No. So if they'd seen that contract, they would have seen, or should have seen, oh, the title search is 5 months old. That doesn't look right. I'm going to do my own title search for my client. Now, had they done that before the auction, the caveat would have been revealed. And then the lawyer would have or should have gone to their client and said, oh, there's a caveat. We better find out what this caveat is, because this auction contract's unconditional.
Yeah.
Then, of course, there was a special condition in the contract. If they had read it beforehand, they would have seen the special condition, right? And they would have seen, oh, there's a caveat there, we'll get it released. Well, hang on, that's a red flag. And the case said that, oh, yeah, the Moorcrofts saw that special condition, but just sort of forgot about it or didn't really know what it meant. Well, they're not lawyers. So
you're not expected to know, but you need people, the right experience to bring up and immediately see those red flags and investigate.
100%. And the court actually said, had the Moorcrofts done more, they would have found out certain things. So leading up to settlement, unfortunately, the court did say, look, the Moorcrofts should have and could have made further inquiries leading up to that settlement date about, well, what is this caveat all about? What is it about? Who's lodged it? Why have they lodged it? And when it was released, why was it released? Because the caveat document itself, when you lodge a caveat, you have to set out the basis. And that caveat talked about fraud. Now, if I acted for a buyer and I found and discovered a caveat on title, then I got a copy of the caveat, which can easily search. It's $50, $60. You get a copy of the caveat and it talked about fraud. I'd be going, hold on a second. What's going on? And make thorough investigations. Okay. And I don't think that was done here, unfortunately.
No.
So moral of the story is get proper advice before and during your transaction.
There you go. Thank you so much, Despina. And coming up next, from buying at auction to a warning to our possible business owners. That's coming up in just a moment with Despina Priala on Talking Law.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.